Good evening. The 1st of January of this year saw 8 new guidelines for sentencing offenders convicted of firearms offences, ranging from unlawful possession of weapons to manufacturing illegal guns. And it's the first time firearms have been dealt with by the Sentencing Council. They apply to all defendants sentenced after this date. And as I said, it's the first time complex offences such as these, while low in volume, that's the words of the Sentencing Council, which can be extremely serious, with several offences carrying maximum of sentences of 10 years or indeed life, and some requiring minimum sentences. But as I said, very low in volume in terms of other sentences. So that introduction by the Sentencing Council tacitly acknowledges some of the numbers involved, and it's worth thinking about that. There are several useful resources that I've looked at during the rating of the article and indeed preparing for this webinar. One of them is gunpolicy.org, and it estimates that there are about 1 million illegal or unlicensed firearms in the United Kingdom. Think about that in terms of the population. Right now, if we take that figure, homicide figures average out at about 750 a year, dropping sometimes to about 600, rising to above 1,100 in 2003. However, in respect of the numbers for homicides involving firearms, that has always remained relatively stable and relatively low in comparison. And the figure averages out at approximately 30 or 40, between 30 to 40 a year. And it's always outstripped by suicide involving a firearm. Now, Marie's obviously mentioned the fact we've all wrote articles on these. So I just thought, just out of way of interest, rather than delving straight into the guidelines itself, is to maybe step back and look at some background information, firstly in relation to deaths involving firearms, but secondly involving statistics involving firearms. And often people talk about whether there is in fact a big gun problem in this country, and it's obviously this is something of an easy hit for me, but just want to compare that figure of 30 to 40 a year to some statistics from the United States. And there's a particularly useful website that I found, so I'm just going to share the screen in respect of that. So if we see that, it's a figure from 2008 to 2017, and it gives you the capacity to click on any state in the United States and see what the figures actually were. So let's look at somewhere, for example, bordering Canada, which is hopefully not a bad figure. And we see that North Dakota gun violence between 2008 to 2017, 784 people were killed with guns in North Dakota, to about 1 person in every 5 days. So not a big figure. Obviously, most people will be thinking, where next? Texas, California? Let's check on California. And there we see the quite remarkable figure. From 2008 to 2017, 30,703 people were killed with guns in California. That's about 3,500 people a year. And we see below that the quite stark figure of 2014 to 2018, 186 mass shootings in California alone. And there we see the figures. So there are quite stark figures. So if you do get people, or it's family, friends, or indeed anyone just saying, is there a gun problem in this country, then there is a perspective to be applied. Let's have a look at the East Coast. We'll look at New York. It's just quite an interesting exercise if one looks at that from 2008 to 2017. 9,165 people were killed with guns in the state of New York. Again, the very sad figure of 76 mass shootings between 2014 to 2018. Going back, and then if we look at Texas, finally, unsurprisingly, sadly, 2008 to 2017, 29,040 people were killed with guns in Texas. And again, the sad figure of 102 mass shootings in the 4-year period, 2014 to 2018. So that's quite a useful exercise. Let's go back to the United Kingdom now, because there has been quite a a downward shift in terms of, a downward trend in terms of firearms offences. Now, I've moved away from homicides to firearm offences in general. So in the year ending March 2019, there were 9,787 offences in which firearms were involved. That is a 4% increase with respect to the previous year. However, and this is an important date, since 2003, there's been a consistent downward trend despite minor recent rises. The number of offences increased by just over a quarter, 27% compared with 5 years ago, primarily driven by non-air weapon offences. But the latest rise indicates a slowing of the rate of increase and a levelling off of the trend over the last 2 years. The 9,787 offences recorded in the latest year was less than half than the level recorded at its peak in the year ending March 2004, which was 24,000. I'm going to use the screen to illustrate this in a moment. 24,094 offences. Last year, there were 33 fatalities resulting from offences involving firearms, 3 more than the previous year. So that fits in with the average being between 30 and 40 each particular year. And of all the offences involving a firearm, the weapon was fired in around half the cases, just over 51% last year. And in most cases, it was used as a threat. As in previous years, offences involving firearms were disproportionately concentrated in urban areas, with almost 6 in 10 offences recorded in 5 areas. They will probably be of no surprise to you as to where they were. The Metropolitan Police Area, West Midlands, West Yorkshire, and the Greater Manchester and Merseyside areas. And this is the kicker, sort of, in terms of the victims involved. Younger age groups with 56% aged between 15 and 34. And that is more than twice the proportion this age group makes up in the total population of England and Wales. So I'll just share the screen now just to illustrate that particular point. Just bear with me a second. This is the National Office of Statistics I've got this from. So let's look at this figure. So the figure in April 2002, 24,070. And as I said, there's a downward trend, a consistent downward trend to around about 9,000 last year. Now, if we follow that down, we see it drops down to the figure of 7,729 April 2013. Obviously, 2003 was marked by the mandatory minimum. So on the face of it, that appears to have worked as a deterrent, because there's been a fairly steep dropping off, which has been maintained. So recalling, just and this is a matter for discussion amongst yourselves, I recall jurists, whenever I've studied all the way through my law degree, through practitioner years, deterrent sentences, do they really work? Well, it looks very much on the face of it as if it worked in respect of the mandatory minimum for firearms. Right, let's look quickly at the guidelines. I'm not going to deal with them at any great length. Marie obviously set out the fact we'd all written articles for them. There's just 1 or 2 points I'd wish to raise, quite interesting points, you may well think. Again, issues practitioners may well have when we're running up against prosecutors and indeed judges dealing with these offences. But one of the harm factors is stated as a close connection to OCGs. And I think this will be a particularly interesting criterion to follow in terms of development, because you may well think this is quite easy to assert, but quite difficult to contradict. It's the bottom line is they could say, well, if you're dealing with a firearm, other than the transfer or the purchase of a firearm, where else are you going to get it from other than from an OCG? So if you're a defence practitioner, that's going to be something of a problem. However, we'll wait and see. One of the points may well be is, how do they evidence that? Are they going to be put to strict proof? I somehow doubt it. With regard to most sentencing guidelines, category 2 obviously falls between for harm, allows for a balancing exercise, for example, where a single firearm has been transferred between a large geographical area, that would effectively cancel each other out in respect of the harm category 2. Dealing with one of the factors that links both the firearm part of this talk and indeed the drugs part of this talk is disparity. And disparity was part of the reason there was eventually a guideline in respect of firearms. Analysis conducted by the Council in preparation for the guidelines suggested disparities in sentence outcomes for some firearms offences were based upon ethnicity. And the Council has repeated throughout the guideline, there are numerous references to disparity. And indeed, I think there are at least 10 references to the equal treatment bench book. And it's a good thing that it's been brought in, but we'll wait to see how it works. Practitioners, in my view, will be cautiously optimistic in respect of the guidelines, looking at the impact upon sentences, and the fact there is an acknowledgement, an attempt to try and address racial disparity can, in my view, in this particular situation, only be a good thing. With that, I'll hand over to Sarah, I think, who's going to deal with some disparity in respect of drug offences. Are you there, Sarah?
I am indeed, thank you. So as James says, what I'm going to deal with is the situation in relation to the new guidelines for drug offences. The Sentencing Council seems to have been very busy recently, because not only have they been updating the guidelines in relation to firearms offences, but also following various consultations. They've issued new sentencing guidelines for drug offences, also to take effect from the 1st of April of this year, so just in a couple of days' time. Those update the guidelines which have been in place for drug offences under the Misuse of Drugs Act since 2012. So they've obviously been in place for some time. So that includes possession with intent to supply, importation and production offences. Now, not only do they update those guidelines which have already been in existence for some time, but they also introduce new guidelines for offences under the Psychoactive Substances Act of 2016, so guidelines that we haven't seen before. And it seems quite clear from kind of taking a global view of all of those guidelines and from the Sentencing Council's own introduction to them, that really what they're seeking to do is to attempt to reflect modern drug offending and the ways in which it's developed since 2012. Of course, practitioners who are attending here are going to be well familiar with the sentencing in drugs cases, the fact that they can be complex, particularly in multi-handed operations, and they're generally highly fact specific. So I'm not going to be trying to teach any of you anything that you don't already know about the guidelines and the way that they operate. Really what I'm seeking to do here is, off the back of the article that's already been referred to, is really give you a bit of a whistle-stop tour of what I suggest are 4 general areas within all of these guidelines, which may be of particular interest to practitioners going forward, and things that we may well want to keep an eye on to see how they develop. So let's start with what's completely new, and that first area is in relation to psychoactive substances. Now, as I've said, these are the first guidelines for offences under the Psychoactive Substances Act. And one thing that's immediately striking is that in respect of culpability, the factors to be considered are pretty much identical for those for drugs which are classified under the Misuse of Drugs Act. What's potentially more interesting is the question of harm, and the starting point for harm focuses on the circumstances in which a substance is supplied, rather than what that psychoactive substance actually is. So there is simply no distinction on these new guidelines for different psychoactive substances, perhaps telling of the fact that actually we're not quite sure how to deal with different types of psychoactive substance yet. It's of particular note, I would suggest, that the guideline states where evidence is available as to the potential effects of the substance and the harm likely to be caused by those effects, the court should consider whether this affects the category of harm. As it may well be that this is a particular area of dispute going forward, and an area that really is going to require some further development, both through cases to start with, as we see the implementation of the guidelines, and then potentially through further review from the Sentencing Council going forwards. Because rather unsurprisingly, given that it's a new guideline, these ones at the moment are somewhat sparse on detail, and it raises some questions for practitioners. How are these potential effects of a substance going to be determined? Who's going to be qualified to determine what those effects are? And to what extent should a potential effect change the categorization of harm if that's not something which has actually taken place? So as I say, it seems to me that that may well be an area of particular interest as we see how the courts implement these guidelines going forward. So moving on to my second general area, which is the question of financial advantage and role, and that's really flipping more to the guidelines under the Misuse of Drugs Act offences. One area which practitioners may have found could be particularly tricky to handle when sentencing in relation to those guidelines and the previous guidelines for Misuse of Drugs Act offences was how to treat an offender's benefit. And that could be particularly so where you're dealing with a low-level offender, because any financial advantage, no matter how small, for a low-level offender, seem to push them immediately into significant role and exclude them from being considered as a lesser role. The new guidelines are potentially of more assistance, but again, I'd use that phrase that James has already used, that is perhaps for cautious optimism. So what the new guidelines make clear is that an individual who expects limited, if any, financial or other advantage, including meeting the offender's own habit, should fall into a lesser role. And to be considered as a significant role, that advantage needs to be a significant financial or other advantage. So it's potentially promising in that it could assist with ensuring that those low-level offenders who really aren't receiving very much by way of financial advantage, but are doing more than meeting their own habit, you know, potentially getting a little bit of money on the side, may be able to get themselves into that category of lesser role rather than being pushed into significant. Now, the third point, maybe of general interest, is the indication that the Sentencing Council are going to continue to review the categorisation of weights and yields in the guidelines. Again, really stressing that what they're trying to do, it seems, is to keep pace with the way that drug offending is moving forward and will continue to modernise, in effect, as it does with the production of drugs and what they're able to achieve. I'm not going to go into all the minutiae of the differences in the category, I can't even say the word now, in relation to the categorisation of the weights and the yields in the old guidelines compared to the new guidelines. And you can find some examples of it in the article, and I'm sure you'll look at the guidelines for yourselves in any event. But the more interesting development is that they have clearly set out that what they're going to do is in fact review those harm starting points in relation to the yields and the weights every 3 years. So there's a real indication that they're going to try and keep pace with things as they develop rather than leaving things for another 9 or so years. So again, it's a clear sign that practitioners need to keep an eye out for those updates in the future. And that brings me on to my fourth and final point, which really, in my view, is perhaps the most interesting in relation to these updates on the guidelines, and that's the question both of exploitation and disparity in sentencing. And again, this is an attempt in relation to the exploitation question of the Sentencing Council, seeking to reflect the changes in the drug supply chain, and in particular the prevalence of the exploitation of vulnerable people. And that exploitation, as many of you I'm sure will know, can take various forms. It can be cuckooing, for example, using the home of a vulnerable person, exploiting children, or running county lines. And the new guidelines address this differently to the 2012 guidelines. I'm not going to focus on exactly how they were handled with the 2012 guidelines or the case law that therefore governed them. Suffice it to say this, that rather than exploitation being determinative of role, the 2021 guidelines introduced new aggravating factors to reflect exploitation. Those are factors such as exercising control over the home of another person for drug-related activity, and also targeting of any premises where children or other vulnerable persons are likely to be present. There are also aggravating features that deal specifically with child criminal exploitation. And we know that that kind of offending has become particularly prevalent in relation to the rise of county lines drug trafficking and operations of that nature. And I think that's the interesting question, is that therefore treating this as an aggravating feature, how is that actually going to affect the lengths and kinds of sentences which are being imposed? It could potentially lead to an increased nuance in sentencing, as it seeks to recognise that offenders who are lower down the chain, as we would view it, may also be involved in the exploitation of vulnerable individuals, which therefore can be reflected as an aggravating factor in the way that they are sentenced. There is potentially within that, though, a risk factor that practitioners may want to be aware of. It could mean that those who are vulnerable themselves could be seen within this operation of a chain of exploiting other vulnerable individuals, which essentially pushes them up and aggravates their sentence. And it's unclear exactly how that's going to be managed. So certainly something to be aware of and to keep an eye on going forward. And that really brings me on to that final and very interesting issue, which is that the guidelines also attempt to tackle racial disparity in sentencing. And again, echoing what James has already said, an area for cautious optimism, but encouraging that it's being taken into account and at least put into writing on the face of the guidelines themselves. It does seem that practitioners will be wanting to approach that relatively cautiously, and it's really questionable how much the fact that the guidelines state that sentencers need to be aware of the disparity in sentencing, is it going to mean any real meaningful difference to the sentences that they pass? But perhaps this is just a starting point, and again, something that we need to keep an eye on to see how they develop. So thank you very much. I'm going to hand you back over to Marie.
Thanks to both Sarah and James. So far, no questions. That's fine. You may all be picking up on what I was saying at the outset about being well aware that everyone's anxious to head off to their evenings. There's just a little bit more that we wanted to cover with you. I think it's really interesting thinking about what James was saying there about the firearms sentences and what happened when there was the introduction of the minimum term. I was certainly very surprised to see that graph with the figure of the drop-off after the minimum was introduced. And I wonder if that also surprised many of you, even knowing what you deal with in your own practices. Both James and Sarah have referred to disparity in their articles and also in the key points that they've highlighted this evening. And it's something that, as James's article specifically refers to, it's the first guideline where a disparity in sentence or disproportionate impact, which is what it really is set out specifically in the guideline. It does appear in the drugs one as well, as Sarah mentioned. And the recently updated bench book, the Sentencing Compendium, has a covering letter from the chair of the Sentencing Council. And within that letter, there's a specific reference to the firearms guideline. And it says this, that this too will encourage sentencers to refer to the equal treatment bench book. It will refer to evidence in relation to some of the offences covered by the guideline of disparity of sentence outcomes as between white, black, Asian and other ethnicity offenders. There may of course be many reasons for such differences, but all sentences should be aware of them. It goes on to say this is an area to which the council, the Sentencing Council, is likely to return. We all want to ensure that the guidelines are applied fairly. I thought it was really interesting when I saw that, and I thought it was worth drawing your attention to, partly because of the reference to this is an area to which the council is likely to return. I mentioned earlier this evening the fact that they've updated all of the guidelines in relation to the sentencing code. I would very much expect that they will update them all in relation to how they're going to draw in this disproportionate impact point in relation to other guidelines. And of course, it's encouraging that there's a reference to the fact that the council will return to it. And even for now, I suppose, the plea that the guidelines are applied fairly is somewhat of a significant step forward, although in itself it doesn't actually seek to achieve much. And really, what I've been thinking about is how it actually is as advocates that we urge courts to really apply this principle when we're mitigating. And that's something that each of us will have to grapple with and find our own way in which to put that properly before the court. But I really would encourage everyone to be bold in their submissions to ensure that there's a little more than lip service given to this. It's so significant that it's been enshrined in these guidelines and should continue to be so. The fact that finally there's this acknowledgement about the disproportionate impact of sentencing. It's really a question of how we actually bring that to the court's attention. And I suppose it really fits in with what James was saying about the point about OCGs and that being almost a sort of throwaway extra feature within the firearms guideline. And it's thrown out there, and what really we meant to do with it. Also rhetorically, I asked, what are we meant to do with this suggestion that we can say, well, look, there is a disproportionate impact in terms of sentencing. It's got to be more than that. We need to find a way where, in a case-specific way, we can actually draw attention to specific features of our clients' cases and make sure that the courts do more than simply pay lip service. Of course, you'll all be aware there's a real interplay there, and particularly with young people, and often with modern slavery offences. And there's a promised guideline to come on modern slavery specifically. And that's a key feature, as Sarah's mentioned, in the drugs guideline. And you may also be aware that recently there has been published a specific bench book for young defendants in the Crown Court, which also picks up on some of these themes. So there really are a number of developments in sentencing, and specifically in relation to young clients. You may think, some of you, that they're positive developments. The sentencing code has some positive aspects. We've got these new guidelines that we've been looking at. You'll be aware there's the mental health guideline that came out in October of last year. And some of you will have attended a lecture that we had with Dr. Hillier, a consultant forensic psychiatrist, who was speaking to those. And that lecture will shortly be available on our Libertas I'm mixing up my tabs, our Libertas YouTube channel, if you weren't able to attend it. So a lot of developments, as I say, but we've also got what is to come. And an examination of the proposed new police crime sentencing and courts bill potentially gives perhaps a different focus and maybe, possibly, we will see, but a less positive prognosis for developments in sentencing. Now, you'll all be aware that there's been perhaps an understandable focus in the media on the protest aspects of the bill. The Shadow Justice Secretary, David Lammy, has described the legislation as a mess, and he's referred to the government trying to rush through Parliament poorly thought out measures to impose disproportionate controls on free expression and the right to protest. There's obviously a great deal that could be said, and as I say, the media's already drawn particular attention to those aspects. But in the few minutes that we've got left with you this evening, what we wanted to draw your attention to is perhaps some other aspects of the bill that haven't yet had as much attention, but that may have most impact on criminal practitioners. Those include proposed increases in sentences for death by driving cases, and that would apply specifically to an increase to life sentence from 14 years for death by dangerous and for death by careless driving when under the influence of drink or drugs. There's proposed increases in the sentence for assaults against emergency workers, proposed changes to sexual offences, and specifically where those in positions of trust are involved, such as sports coaches and religious leaders, which you may think by definition will mean increased sentences in those areas. There's proposals for extended use of community sentences. Many practitioners at the moment in courts may ask themselves how at the moment that's going to be affected when probation are often saying that they simply can't manage any rehabilitation activity requirement days or community services or programmes because of the backlog. And also there's proposals for increasing the use of electronically monitored curfews. Again, I wondered to myself how for some people that may be very little difference to their current situation, bearing in mind the recent national conditions, but that remains to be seen. And I've referred already this evening to a lot of developments in youth sentencing. Another one potentially to come through the bill will be changes to how detention and training orders operate and how remand time is taken into account for sentences for young defendants. So I've really just whizzed through there a few of the key proposals. Sarah, I know that also there's one area of these proposals that's particularly excised you.
Yeah, thanks, Marie. Yeah, I think one area that's quite interesting, which is hidden away in there, it is something that you've already referred to again in relation to youth sentencing. And it's actually something to be found in part 7. It's in chapter 1. It's currently clause 103. And that's the proposal to include starting points, minimum starting points for murder for those who commit that offence when under 18. And there's in fact a table for the different ages and for what that minimum sentence could look like. One thing that is interesting is that it includes a starting point for offenders aged 14 or under. And that really, to me, seems to be one of those aspects that is potentially the most concerning, because there seems to have been a recognition in our approach to youth sentencing for some time, that of course youths and children have not developed to the same extent as adults, and that of course has to be taken into account in relation to their sentencing exercise. That is particularly true of those who are under 14. You know, we really are talking about people that in many ways are still children, although I doubt they'd like to be referred to in that way if my experience is anything to go by. And I think the difficulty with suggesting that there should be a minimum or that should be a specific starting point is that it takes away the opportunity for the court with those very young people who have committed a crime, which is fortunately very rare for it to be committed by somebody of such a young age, but it takes away the ability of the court to approach that in an extremely specific way, both for that of individual and the offence that they have committed, to ensure that it's really dealt with in the best way that it possibly can be in those very tragic circumstances. And it seems to me as well, but particularly this aspect of it for being for young people who are under 14, it potentially ties into a wider conversation about actually have we got it right in relation to the criminal justice system for young people? Should we even be including people who are under 14 within that system? Does there need to be some adjustment for the age of criminal responsibility? And so that really is a wider conversation, I think, that we haven't yet really had, but it may be something to come in the future. So yeah, I did find that one aspect that was particularly interesting. Unlikely to affect most of us on a day-to-day basis, though, I accept.
Yeah, and I think, as I've mentioned already, so many changes in youth sentencing and approach to young people, and I suspect that's one of the areas that will draw a great deal of attention and input. and it remains to be seen what will survive the bill and what will end up ultimately in the legislation. But I agree with you, it's a real area to look out for. James, back to you. You wanted to draw attention to another key part of the proposals.
Thank you. I just want to make this point. I agree with David Lammy. Much of this police crime and sentencing courts bill is a bit of a mess. But in relation to sentencing, the landscape of sentencing is constantly changing. It never seems to be given time to settle. And the last thing you want is a knee-jerk reaction to a particular event. Luckily, we are blessed with such legal heavyweights as Suella Braverman and Robert Buckland, so they would not react in that way. Well, maybe they wouldn't anyway. However, there is a particular part of this in relation to the automatic halfway release for certain serious offenders, where the law is going to be changed when it was only brought in April 2020. Again, this, in my view, is in relation to two particular terrorist offences, and this is a knee-jerk reaction, and not the law they brought in April 2020 has not been given time to settle. But this is what Robert Buckland said when he was quoting this to the House of Commons. When a prison sentence is passed, yes, there is a period on licence during which the individual needs to readjust with the appropriate controls, but there has to be a clear signal that the bulk of the terms will be served behind bars. That is what the public expect. That is what will increase confidence in the system. That is what we are doing. So that is the rationale. So in April 2020, they brought about the release of prisoners. It's called the Alteration of Relevant Proportionate Sentence Order, which ensured serious or violent offenders who received 7 years or more served 2/3. That's now to be changed to 4 years. In terms of bedding down of sentencing, that I think is a knee-jerk reaction. There is enough within the scope of the sentencing judge to prohibit what they're concerned about. And I just worry it's the constant changing of the landscape. But that's just all I want to say about that.
Yeah, absolutely. Well, as I mentioned, it does remain to be seen what the final shape of the legislation will be, and we'll be keeping a keen eye on it. And there'll be more from the three of us specifically in relation to reviewing the Act once it's passed. And we're going to plan to make that available on the YouTube channel that I mentioned earlier, so that you can dip into it at your leisure. If you can bear any more of the three of us speaking to you about sentencing, it would be really great if you'd have a look at that in due course. So really, I suppose the last few comments from me before I pass back over to Sarah to see if there's any questions, it is just to urge you, if you're able to, again, bearing in mind the comments about lighter evenings and so on, to sign up for the final lecture that we have in this series due next week on autism with our Felicity Gerry, Queen's Counsel. And also to thank both James and Sarah for this evening and for what they've been summarising to you, and commending the articles that they've written to you as well, to go away and have a look at and see the wider aspects that they've drawn attention to. So Sarah, with that, I'll just hand back to you and see if there are any questions.
In fact, it was an excellent segue, Marie. And of course, firstly, thank you to you also for everything you've done this evening. The question that is in the chat at the moment is, where do I find the articles that you refer to? It's a very astute question. So following on from what Marie just said, those are actually posted on our various social media platforms. So you'll find links to them both through our Twitter account and also our LinkedIn account. But what we will also do is, given that we have the sign up for everybody, and I know who it is that's asked me the question, I'll make sure that those links get circulated to you via email as well, so that you have what we've been referring to, so you can just have a brief catch up in relation to those two.
Brilliant, thank you, Sarah. Okay, good. Well, we now will let you go then to your summer evenings. I've got to sort out this dodgy wavy thing that I have on my screen with our Libertas background. We'll work on that for next time. But it's been really nice to be with you all. Thank you again for persevering and bearing with us. And you're released into the summer, into the garden. See you all soon.